You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And, this has been just a disappointing week. Or
that
two.
was a very polite thing to say, Gary.
Yeah. Well, there's other things I want to say that you won't let me say. So there's that. We had some disappointments in the Supreme Court, which most of the world by now knows about.
Right.
I think I saw a bunch of tweets going out that George W. Bush owes the nation a huge apology for Chief Justice Roberts.
Oh,
and
yeah.
And so there's been some challenges, certainly in the Supreme Court. And, of course, as of we're recording this on a Friday, and as of yesterday, we had some shenanigans
unexpected
go on in the House and the Senate here in Tennessee. So pertaining to our abortion bills. So we'll get into that. But I guess first we can dive into a couple of these Supreme Court rulings. And so I'll let you bring up whichever one you want to torpedo first. We'll talk about
Monday started off in a really rather shocking manner when Justice Roberts joined with Justice Gorsuch in an opinion written by Justice Gorsuch.
Which honestly, I said Justice Roberts, but on the opinion you're mentioning here, Justice Gorsuch, which was probably the bigger surprise.
The bigger shocker. Yeah, that was the bigger shocker. When I heard it was a split court, I thought, well, it's 5-4, and Roberts joined the liberals again. And when I read it was 6-3.
Wait a minute, it's 6-3. Who could that be?
It was 6, and it was Gorsuch. And what they did, for those that don't know,
this was the Title VII thing, right?
This is Title VII is of the Federal Civil Rights Act, and it prevents discrimination in the workplace on the basis of race, national origin, religion. I can't remember what the others are. The standard ones, and the word sex. Now, it was passed in 1964, and the question was whether or not the word sex meant being discriminated against because you're a male or discriminated against because you're a female.
Yeah, did they mean biological sex by using the word sex?
Instead of putting the words race, religion, national origin, male or female, they used the word sex, which is in 1964, everybody knew it was biological. And as Justice Alito made very clear in his dissenting opinion, the primary definition of the word sex in all the American dictionaries today is still biological. It has nothing to do with sexual orientation, the code word for homosexual activities and feelings and thoughts, or however you want to describe it, or gender identity, thinking subjectively that, well, I know my anatomy, my biology, my chromosomes are all male, but I feel I'm a female, so I want to be treated as a woman. And of course, this concept of transgender and gender ideology didn't even exist in 1964. It was a mental disorder. The same was true of homosexuality. It was a disorder. And so what the court is supposed to do, and they even give lip service to the idea that we're supposed to construe the words as they were understood and used at the time they went into the statute.
Which Gorsuch, being a self-professed originalist, you would think that's how he would apply.
Yeah, that's right.
That word to the 1964 law.
That's right. You'd think that's exactly what he would do, but he went on about all kinds of things that, excuse me, as Gorsuch, as Alito made clear that were irrelevant, like the act applies to individuals and a few other things that were just strange. And hocus pocus, somehow it came out in Gorsuch's mind that the word was not absolutely crystal clear, and the intent was somehow a little ambiguous, and therefore it could include sexual orientation and transgender ideology. And of course, Alito pointed out that, well, the fact that today it could be seen as that way does not change what it was at the time the word was used. So it was just
And so,
shocking.
Bottom line now
Title they rewrote the law.
Now Title VII labor laws are going to protect, according to not just sex but sexual orientation and gender identity. Essentially, is what's come out of this ruling. How do you what are some warning signs, or what are some things that you think that we should be looking out for? How could this have a greater degree of impact than perhaps we're realizing it will today?
Oh,
I know that's a loaded question to put on you. But maybe just pick one.
For instance, a friend of mine who's a lawyer and does litigation said, one of the things that you could have is under Title VII is hostile workplace environment type claims. That you've created an environment that's hostile for women or men, transgenders, homosexuals, whatever it is. And so if you're a Christian employer, let's say, and you support organizations like ours or Family Research Council or Alliance Defending Freedom or, whatever it might be, Liberty Council, then if you fire somebody who's transgendered or homosexual, then it becomes easy for them to argue, if nothing else, for the settlement value, that, well, maybe there were lots of considerations, including maybe the quality of my work or how untimely or not untimely I was, but we also know that you're hostile to my transgendered identity and my homosexuality, and therefore that was a reason, a factor. See, you don't have to prove under Title VII that it was the reason. It's just a reason.
You almost just have to make the suggestion that it was potentially a reason.
Yeah, that it factored into the decision, right. And so the employer can say, well, you were actually late 5 times last month, and I told you not to keep being late. Yeah, but you don't treat everybody that's late the same way all the time, and we know that you're actually hostile to homosexuals or whatever because of your affiliation. So we're going to start seeing presumed guilt or suggested guilt based upon association.
Do you see this current ruling in any way being able to make its way into faith-based organizations at this point?
Yeah, absolutely. Now, there is an exception in Title VII, and maybe you have it in front of me. I don't have it, but it would clearly not apply.
Particularly for churches.
For a church, it should protect the church. Now, I'm not going to be surprised. I mean, if we can reinterpret what the word sex was in 1964, when we didn't even have the term sexual orientation or gender identity, to say, well, if you're simply hiring a secretary for your church, or the web designer, or custodial help or kitchen help for Wednesday night suppers or something, well, that has nothing to do with the teaching of your religion. So, who knows? They're liable to
certainly we can redefine religion. Yeah,
we can say these are not essential to your religious purpose. And then there is an exception, for instance, for schools if they're owned by essentially a church. So, for example, in Tennessee, we have a lot of church-owned schools. A lot of the independent Baptists, for instance, have schools that are attached to the church. But we have a lot of, Christian schools, or schools that are Christian in their character, flavor, tenor, that are not attached to any denomination or particular church. Well, they're probably not going to be included at all.
You could argue that their primary function is not religion, and so they're not protected
it's just
under
education. That's right. So, Yeah. So yeah, I think it'll reach its way into a lot of things. I'm not even sure how it would affect things like Fellowship of Christian Athletes and InterVarsity, because they are not, while they're religious organizations or Christian organizations, they're not owned by or under the authority of a denomination or church. So it'll create lots of questions there.
Yeah.
And of course, for organizations like the Boy Scouts, of course, they capitulated of their own free will, but
Right.
But it could affect the organization that came out of that, which was Trail Life,
Yeah.
the alternative to the Boy Scouts, because while they're a Christian base, they are not, owned by any religious organization or anything like that. So,
Yeah.
So it's going to be a problem.
Yeah, and before we get to the next issue, it's also worth noting that this ruling on Title VII is just another example of judicial supremacy, where the Supreme Court takes on the power to amend a statute, the law passed in 1964 by redefining words, and so they again become a de facto legislative body. I mean, because this issue, right, of protecting gender identity, this has been in Congress, and it's not been able to pass through Congress, so the court just did Congress's job for them. It's anyway.
Essentially, the court didn't want to make a politically, socially difficult decision, so it found a way to get around it.
You mean Congress? You mean Congress didn't want to make that decision? Yeah.
Well, so Congress didn't.
So they let the court do it.
But neither did Roberts or Gorsuch. They didn't want to say, I'm just sorry, all y'all out here. This is for Congress to do, and go see them. They found a way to get where they wanted to go. And what's interesting, this is sort of like the marriage decision in 2015. We've had marriage as a man and a woman, and we've understood that to be what it is, that the U.S. Constitution did not address domestic relations, family law at the state level. The Supreme Court has rejected that for 200 years. And then all of a sudden, we've discovered that marriage actually has nothing to do with sex, and states aren't free to decide for themselves how to handle domestic relations. Well, Alito pointed out in his dissent that since the law was passed, I think it was 9 different decisions by federal circuit courts had all held that sexual orientation is not part of sex. I think 3 or 4 had held that transgender was not part of sex. So all those federal circuit judges, one step below being on the Supreme Court, have since 1964 all not been smart enough to see in those words what Gorsuch and Roberts saw.
Yeah, so much for precedent.
In Obergefell, they at least said, well, except for the Sixth Circuit, all the circuits think marriage is a federal issue now and blah, blah, blah. But here, all the circuits were against them.
No circuits.
And they said, no circuits. And it's kind of like, I think recently he said after 2017, I think the Second Circuit did it. And there's actually a great statement. Let me see if I can find it here real quickly. It was just flabbergasting, but Judge Posner, who I think is now retired, he was in the Second Circuit, and he admitted, he said, I wish we would just, in his concurring opinion, he said, I wish we would just admit that we're acting as legislators and be done with it. And that's what courts do today. I thought it was at least a candid admission. Let's just fess up to what we're doing and not try to hide it here. That's what courts do.
Yeah.
And he was quoted in the dissenting opinion by saying, well, at least Judge Posner has the integrity to admit what he's doing.
Yeah. Tell the truth at least.
Yeah. It's terrible.
So
but that wasn't all the bad news this week.
Yeah, no, we got another one. So jumping into the next one,
that was enough for this week, but we got another one. Yeah,
we are talking about the Daca issue, and of course, which is primarily a separation of powers problem.
Right. Yeah, that was a case where, again, Congress did not, want to address the children of illegal immigrants that were here and the benefits and rights that they would have otherwise. So,
I see a theme.
President Obama.
I'm sensing a theme here from Congress.
Yeah, I mean, and here's the thing about the previous case. For example, Title VII. The court interpreted the statute wrongly. Okay, Congress can say, well, we disagree with you, but we'll go in and we'll change this and we'll just substitute the word male and female. And it's fixed. The Supreme Court's opinion has been nullified. Great. Except Congress is too dysfunctional to do anything. And it won't get fixed. And it can't get fixed.
So in the Daca issue, instead of primarily it being done in the court, it was initially rendered by executive order. So the executive order steps in.
Yeah. So that's even worse. At least Congress did pass, Title VII. But Obama, through the Department of Homeland Security, issued a memorandum in dealing with enforcement of immigration laws and so on and so forth, and said, here's what we're going to do. Trump came in and said, well, he had no constitutional authority to do that at all. And so I'm going to abolish the program by another memorandum. Well, you would think if the argument is, and it's correct, that President Obama had no legal authority to create it, you wouldn't have to have any legal authority to stop violating the law. You just stop violating the law. And so the president said, here's the new memorandum. We're not going to violate the law anymore. Well, Justice Roberts decided, but there are reliability interests that have been created. And so this is sort of like rulemaking. And so it sort of falls under the Uniform Administrative Procedures Act. And we get to review it to make sure the decision is not arbitrary and capricious. And we think your decision was ill-motivated and ill-devised and didn't consider all the factors. And so undoing the program violates the law. And of course, Clarence Thomas, and I think it was Justice Kavanaugh, wrote a concurring opinion. It was quite good. It said, if what you're doing is illegal, you don't have to give reasons to stop doing what's illegal. You don't have to have reasons to stop acting unconstitutionally. So here's what effectively.
And even beyond that, though, you have an executive order from a previous executive that was overridden by another executive order of a current executive. And
so what's the difference?
And so why should the court be involved in that at all? It's not as if President Trump tried to override some existing law that was passed by Congress. These are just executive actions that happen all the time. So I'm really confused as to how the court even saw its place in getting involved in activity that was only happening within the executive branch to begin with.
Well, gosh, Gary, you're just not a good enough lawyer to see that the king really does have clothes on. I mean, that's
no, just a guy with a little bit of common sense. That's all.
Yeah, and they've lost it, and obviously, again, as the dissent indicates, this was to avoid making a politically tough decision and disrupting the status quo, and so they find a way to inject the court into helping decide the policy question. And that's just wrong. I mean, at some point, I'll just say it. Some member of Congress, along with many others, need to file a resolution. It'll go nowhere, but they need to file a resolution to impeach Justice Roberts. And see, our founders anticipated they would do that. When the Supreme Court stopped calling balls and strikes, when the Supreme Court started making policy decisions, the idea was that those who were supposed to make policy decisions would be so put off by it
that they would check
that you're usurping my authority, that they would check their powers. Mm-hmm. But they know they won't. And most people don't know that they could or that they should. And like I say, it wouldn't go anywhere. But it'd make for a wonderful debate and discussion that needs to take place in our country.
That should be had. Yeah, absolutely.
Yeah, that's right. And we used to do things like that in our country. It was really interesting how different amendments came about where people rose up and essentially created pressure.
Yeah.
But we just seem to go, the Supreme Court ruled. It's the law of the land.
We used to debate good ideas. So anyway, I don't think we have to work too hard to convince most people that these two rulings are pretty terrible.
Bogus.
That seems to be the general consensus. So we can spend the next 15 minutes talking about what happened here in Tennessee with our abortion legislation, which I think probably, I'll just say this, at the very least, most people who are interested and want pro-life legislation are a little uninformed of what actually went down and perhaps what this law actually will or will not do that ended up passing our General Assembly. I'll let you speak to a little bit of that because I'll just end up getting myself in trouble. So I'm just going to let you.
Well, it goes back a little context, which we've covered before, but in case we have new listeners or they've forgotten, last legislative session in, March or April of last year, the Tennessee House passed a heartbeat bill, like Ohio and Kentucky have passed, and maybe a couple other states. And
which at the time, if I remember right, was like a 6-week ban.
Yeah, it was. It just said when the heartbeat is
standard.
Discovered, which would have been about 6 weeks. So, but it rested on a constitutional law argument that we thought, along with national pro-life groups, thought was devoid of merit. Let's just put it that way. I mean, you did not see Americans United for Life, National Right to Life. You didn't see Alliance Defending Freedom come into the support of heartbeat bills because it was a waste of their litigation resources to try to defend those laws.
Because still, as we sit here today, every single solitary heartbeat bill that has been passed across the United States currently sits ineffective and either temporarily enjoined by the court waiting for another hearing or permanently enjoined by the court. That's right. Where we sit today. Yeah,
that's right. And the reason is the Supreme Court has made it very clear since 1992 in Planned Parenthood versus Casey that the state does not have an interest in life sufficient to restrict abortion decisions prior to the viability of the unborn child. And so the court essentially did a balancing test on when you become person enough that the state could protect your life. And they said, well, until you're actually viable and might be able to survive outside the womb, you just need to let the woman have her own liberty right to decide what to do. And so that's been the standard. Well, obviously, if you say you can't have an abortion after a heartbeat, that's prior to viability. And the only legal argument that's been made is that we know more about embryology and fetal development than we knew at the time in 1973. And so therefore the Supreme Court should at least protect life from a heartbeat. Now, not protect life, period, but at least from a heartbeat. Okay. Now, so in other words, you could say up until a heartbeat, you're not really enough of a person for us to care either.
And it's worth noting that
fundamentally bothered me.
On that viability standard, that simply by looking at what courts have upheld up till now, it seems to be that it's generally accepted that point of viability is right around 20 weeks. So we kind of sit at this 20-week mark of when the court breaks on allowing any sort of abortion restriction.
That's right. So the argument of the heartbeat people and of the bill last year was that, well, there ought to be an exception. And you ought to change the standard from whether the unborn child is viable to whether the pregnancy is viable, whether or not the child, if not aborted, would actually survive. So you're asking the court to change the standard, the constitutional standard, from viability to survivability. Well, to convince the court to do that, you would normally need to give them a legal argument for why their legal standard is not legally correct. And notice how many times I said legal there. Mm-hmm. But instead they go in and they say, well, we know more about fetal development. And we know when heartbeats start and blah, 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 blah. Well, actually, in the Casey court decision, the court said, don't come to us with arguments about the advances in science. Sure, science might change the point of viability from 22 or 23 weeks, I think is the time it was, to something less than that. But he said this decision does not rest on the state of science. Well, that's actually a good statement. Rights shouldn't depend upon science. They depend upon something more significant and fundamental than science. And the court said, and we've already decided what that is. It's viability. At that point, you become enough of a person that the state has a right to protect the person's life. Well, no legal arguments are made to justify that change, and that's why they've all lost. And then last week, the Sixth Circuit Court of Appeals, which is the circuit that we're in, decided that this argument that there should be an exception to the viability standard based upon the fact that dismemberment abortions that begin at 15 weeks, where you actually tear the arms and legs and heads off.
Yeah, the dilation and evacuation, the DNA abortion.
Yeah, that's right. That justified an exception to the viability standard. Because it was inhumane. And
which in what you say right there, you would think if the court is going to grant any sort of exception to this viability rule, that it would be when you're literally ripping babies apart to get them out of the womb. That would be the exception.
Yeah. And actually your use of the word ripping there is not pejorative. That was in a Supreme Court decision back in 2007.
It's literally what happens.
Yeah, it's literally what happens. So, but the Sixth Circuit said, well, I hate to tell you guys, but the Supreme Court's been clear over and over and over. If it applies prior to viability, it's no good. The woman's liberty interest trumps the state's interest in the life of the unborn because it's not enough of a person. You lose. Now, the 11th Circuit ruled the same way I think it was the end of 2018. And in 2019, the United States Supreme Court unanimously refused to even hear an appeal in a case like that. It was the same argument, same dismemberment ban from Alabama. So the question is, why are we trying to suggest to people?
So let me just get this straight, though, from what you just said. So the 11th Circuit, the 6th Circuit, and the Supreme Court at this point have all agreed that even banning a dilation and evacuation abortion prior to 20 weeks is a no-go, as the current laws are in place.
Yeah. Yeah, the two circuit courts said it's a no-go, and the Supreme Court said we don't want to hear it.
We ain't going to hear it. Okay.
Yeah, and Justice Thomas wrote an opinion actually in 2019 because of all people who would support reversing Roe, he is, and he said, I don't want to hear the case because you've not given me a square head-up direct attack on Roe, and I can't reverse Roe coming in sideways because it'll look like it's political. And we can't do that because we're supposed to be an institution of law. Now, he has the integrity to say that. I want to look like I'm judging the law, not judging political moods and swings. And there's a heartbeat, so the law ought to change. I need to be a lawyer. Give me legal reasons. Well, in any event, because of that, the Senate did not pass the heartbeat bill in 2019. They had a committee hearing in August of last year. And law professor Adam McLeod and I both testified on these issues. So did National Right to Life's attorneys, excellent attorneys. I mean, we have a different worldview, but they at least know what the Supreme Court has said. And we testified that the best way to approach this was to go through the Ninth Amendment, which most people aren't familiar with, and we won't get into the details of it today. But essentially, the Ninth Amendment says that we've tried to enumerate rights in this Constitution, but the people are not giving up their rights. And if you construe any of these rights to deny or disparage the rights that they have by natural law from God, then that's wrong. We kept all those rights for ourselves, and we can exercise them. So we drafted a bill at the request of the Senate Judiciary Committee that says we are asserting as a state the right of the people that they have to the rights that they have as a result of nature and God and so on and so forth, and the common law. And we were going to attack the Supreme Court with a new legal argument based on a section of the Constitution that the Supreme Court had never heard before. So it was a new issue. It wasn't the same old like happened in Alabama or Kentucky, or happened in Missouri and Ohio and Kentucky on their heartbeat bills. They've all lost.
It would be a brand new constitutional argument that Justice Thomas has been asking for.
That's right. That was our thought. So we drafted that bill. We sent it to the governor back in, late October, November, heard nothing. And the next thing we know, the governor's come out with this Missouri laddered bill approach that says, the federal court, let us know at which of these 10 stages of fetal development you'll let us prohibit abortions. And we just didn't think that was a good approach. It was an equivocal statement, if nothing else, that we really believe life is worth preserving when there's a heartbeat at 6 weeks. But if that's not okay, how about 10 weeks? Would you go for 10? Would you go for 12 or whatever else it was?
We had an entire podcast on this already, by the way.
Yeah, that's right. We already did. So anyway, then COVID, so we filed our bill, the governor filed his bill, then COVID came, and the governor said, I'm not interested in this legislation anymore. I got to deal with huge budget shortfalls. The Senate leadership said, we're not going to take these bills up. But the House kept pressing forward, and on Thursday morning of this week, the House went ahead and heard the governor's abortion bill. Now, I'd been told that it would not be taken up in the Senate, that the House leadership was convinced that the Senate was not going to hear it. And but they kept pressing, making the argument that, well, if we pass it, and if we pass it in the same form the Senate passed it, then maybe they'll just be too tempted to let it lie over and they'll take it up and pass it. Well, we kept monitoring what was going on. So they passed it, by sometime yesterday, late morning, early afternoon. And we continued to monitor what was going on in the Senate. And at midnight, literally, 11:58, a motion was made to suspend the rules for the immediate consideration of the Senate version of the governor's abortion bill. Now, everybody interested in the bill had been told for the last several weeks, we're not going to hear the bill, we're not going to hear the bill, we're not going to hear the bill. There was no way to go lobby on the bill because essentially you couldn't get into the building unless you had an appointment with a specific legislator.
Yeah, it's worth noting there were no hearings on this particular bill. There was no testimony on this particular bill.
Well, there had been in the Senate Judiciary
Judiciary
months
Committee,
ago.
There had been
That's
some.
right.
Yeah,
but since then we've been told that nothing would happen.
Yeah.
So we took them at their word. Nothing would happen, and we didn't spend time lobbying and harassing legislators. And I'm particularly sensitive to that. Mm-hmm. As a legislator, I didn't like getting thousands of emails from people on something I knew was already dead.
Right.
Now I got to respond to all these people. So leave them alone. Well, at midnight, all of a sudden, we're going to hear the bill. And it was a trade-off with the House over some budget considerations that, well, if you'll give us some things on the budget, or we'll give the Senate some things on the budget, you give us the abortion bill, is what I understood happened. And so at midnight, they took it up. Democrats obviously complained that, well, our people have had no input on this. They were told we weren't going to take it up. We've been telling them, you're not going to take it up. Don't worry sending emails down here. Don't worry about coming down here. This is just not right. Everybody went to bed tonight thinking it was over. Mm. Well, by 12:30, they had passed the bill. I personally think that's a very bad way to run the railroad. It looks like doing things in the cloak of darkness, and it is pretty dark around midnight. And the bill would have been just as good Friday morning.
Yeah.
It would have been just as bad Friday morning. It would have been whatever it was at midnight, it would have been the next day. And people could have, if they wanted to, made phone calls. They could have sent some emails. They could have contacted legislators and say, hey, have you thought about this or have you thought about that? Well, it all went by the wayside. And that's disheartening because a lot of people came out of those Senate hearings thinking we found a new approach to this issue that hasn't already lost. Mm-hmm. And all these other lawsuits are already ahead of us in the system. So
why put another one in the mix?
So why put another one in? Those other cases are going to decide for us whether our law is good or not. And we'll have no different legal argument. So what are we doing? Now, at 12:30, 1 o'clock in the morning, you're not thinking as clearly as you might. And I want to say something here for those that are discouraged that the Rule of Law Life Act essentially was given no consideration. And that is this. There's nothing in the governor's bill that would prevent the Attorney General from still defending it on the basis that the legislature has a right to actually stop abortion at the heartbeat because of the Ninth Amendment powers belonging to the people or rights belonging to the people. There's nothing that would prevent legislators, for example, from asking us to file amicus briefs, or if the Attorney General won't make the argument, to ask us to represent them and intervene in the lawsuit and make the legal argument. Yeah, I know the bill says anywhere from 6 weeks up to 24 weeks. But we want to say as legislators, we think we have the right to do it at the heartbeat. We have the right to do it at the moment we know there's a life there. But so we really don't care about all that other part. There's a constitutional basis for upholding the law without going through, each of these 10 different stages of fetal development. And I hope we'll be able to encourage the Attorney General to make that argument, or get some legislators willing to make that argument, because many legislators actually said, we don't like the governor's approach. We think he's abdicating the legislative policy decisions that the legislature should make to federal courts and run into the courthouse with their hat in hand saying, what can we do? And many thought that way. But, it's hard to vote against a bill that looks pro-life, because there might be another bill that might have a better approach when that better approach isn't in front of you and you can't vote for it. I mean, it'd be a very hard thing to vote against the bill and then explain to people why you didn't look pro-life. So we're going to try to make lemonade out of the disappointment that the work that we did for a year and that we actually did at the request of the Senate was just ignored largely by the governor and the legislature. And no sour grapes. It is what it is. The people, the representatives have spoken, and now we're going to do the best we can to make the right legal argument. Yeah. And that's all we can do. So,
I guess the tiny sliver of hope is that somewhere buried in that bill, they actually did mention the Ninth Amendment. So
yeah, that's right.
So like you said, if at the very least that at some point later on down the road opens the door for us to be able to come in and make a rule of life
type argument. That's right.
On behalf of.
We can say it was in the Ninth Amendment was referenced.
Yeah.
So it's not like we're just coming from left field. So I hope, the work I'm writing a law review article. We're working with professors. I hope we can get them to the governor and the Attorney General and say, look, would you really take this seriously and look at making this argument, make whatever argument you want, but make this one too. When lawyers go to court, they're not limited to making one argument. They can say, well, this argument wins, but if you don't like that argument, this argument wins. And so I hope we can help make sure that the best legal arguments are made.
It's a hard loss, and I know it's super hard on you. You've been fighting this for 25 years or so. So I get that. But I've lived this day and night too, and it's hard and it sucks. But as I think about all the conversation we've had over this podcast, as much as I want to be mad and frustrated, with the politics of this all, at some point what you realize is that the root of all of this is that we have truly, as a society, as a whole people, have forgotten that we have rights that are God-given, that exist outside of the Constitution and come from a higher authority than government.
That's right.
That of everything we've talked about, now up to 31 episodes of God, Law, and Liberty, that is the root of the issue that we face when we talk about abortion, or when we talk about marriage, or what men and women are, or any other policy that we have issues with. We've simply forgotten where these rights actually do come from, and they don't come from the government.
That's right. And we've been afraid to assert them.
Yeah.
But the encouraging thing is, and I'll kind of just say this too, in working with law professor Adam McLeod, he says there are Supreme Court precedents for this legal argument. We just don't use them anymore. But they exist. They've never been overruled. We've not found a way to access them, or we've not found we've thought, well, it's just not prudent to raise it. We're going to lose. Well, it looks to me like we've been losing for 47 years the other way. So why not go back to, in essence, the concept of God is the great lawgiver, and we have law that the laws of men are subject to. If we're not ever willing to make those arguments, then we deserve to have our rights lost.
Well, that's a bit of hard truth to swallow, but you're absolutely right. Yeah, we said that before. If you keep electing people that don't hold those rights to be self-evident, and you put them in power, at some point you've got to recognize that you're going to lose those rights.
Yeah.
All right.
If you insist on playing the game by the other guy's rules all the time, eventually his rules will eat you, won't they?
That's true.
Yeah.
A little bit of truth for you there as we leave you here on with that thought on God, Law, and Liberty. As always, we encourage you to please subscribe, share this podcast with family and friends. You can email us at info@factn.org. That's info@factn.org. And hopefully in the next couple of weeks we've got some encouragement to bring towards your way. But for now, be mindful and be prayerful with us about next steps as it regarding abortion here in Tennessee and what God might do, because the ultimate thing, I think one of our board members sent an email that circulated around the group earlier that, hey, guess what, in all of this that happens, God is still on his throne, and God is in control, and that's the God that we serve. So
Amen.
I'm going to hang on to that little bit of truth as we close. So
Amen.
God bless you. See you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.